Hi guys, welcome back to Nairobi Legal. In today's video, we're going to be focusing on the elements of a valid marriage. Remember that marriage in Kenya is regulated by the Marriage Act of Kenya 2014. And as a family law student, you must be in a position to understand the elements of a valid marriage within the context of Kenya. Now, for those who are new to Nairobi Legal, consider subscribing to this YouTube channel so that you receive notifications each and every time I share a new video, and don't forget to give a thumbs up for this video. Before we discuss about the common elements of a valid marriage in Kenya, I want us to first appreciate that we have different types of marriages in Kenya, and these range from Christian marriages to customary marriages, civil marriages, Islamic marriages, Hindu marriages. All these types of marriages are recognized in the Marriage Act of Kenya 2014, and each one of them has its own specific legal requirements for it to be considered valid within the Republic of Kenya. So that said, I want us now to look at the common elements of a valid marriage in Kenya. Now, the first one is that according to Section 4 of the Marriage Act of Kenya, you must have attained the minimum age of 18 for you to actually go into a marriage, meaning that you cannot contract a marriage unless you are at least 18 years of age. Now, the reason why I'm emphasizing this statement with a section is that as a family law student, anytime you make a statement, whether in an exam or in a discussion, you must provide a specific section of the law to back up what you're saying. Now, the second common element of a valid marriage is that it requires witnesses. And I'm sure if you've attended a church marriage or a Christian marriage, I'm certain that you saw witnesses, and these are people who were present during that marriage ceremony. They observed that ceremony. They attested to the celebration by signing or putting a mark on the certificate. There's a certain point at which where two people come to sign a document at the front of the church. Now, that is never formality. The law requires that to be done, and that is in line with Section 5 of the Marriage Act of Kenya 2014. Now, also remember that these witnesses have to be competent, and they must be two. This is a legal requirement. They can't be less than two. Yeah, and there are also situations where a witness can be considered incompetent, and examples here would be that if that witness is below 18 years, or that witness was intoxicated at the time of observing the marriage, or even that witness did not understand the language that was used to conduct that marriage ceremony. An example would be that if two Kambas are getting married and their Japanese friend who does not understand Kamba is their witness, and the language that is being used during that ceremony is Kamba, that makes that witness automatically incompetent because that person does not understand the language. And so you need to appreciate Section 5 of the Marriage Act of Kenya. And the other point you need to note is that these two competent witnesses must exclude the celebrant, meaning that they are different from the bride and the groom. So understand Section 4 and Section 5 of the Marriage Act of Kenya. These are never formalities, but the law provides for the same. At the back of your mind, you need to remember all the time what Section 8 of the Marriage Act of Kenya means, and it speaks to conversion of marriage. Remember that in Kenya, a marriage can be converted from a potentially polygamous one to a monogamous one if both spouses agree. Now, remember that we have African customary marriages, and these marriages by their nature are potentially polygamous. You can marry any number of women you want, and the law provides for that. Yeah, but there's a situation whereby you have had a traditional wedding and you're married under African customary law, and you want to convert your marriage from being potentially polygamous to monogamous. And if you go ahead to agree as husband and wife, according to Section 8 of the Marriage Act of Kenya, then you can actually succeed in converting your marriage from being potentially polygamous by virtue of being an African customary marriage to being a monogamous one. But there are certain conditions to be met for this to happen. And the first condition is that the husband must have only one wife at the time. And this is according to section 8.2 of the Marriage Act of Kenya. Meaning that if you are married under African customary law and your husband happens to have 2 wives or more, then your husband cannot come and try to convert a marriage between one of his many wives from being potentially polygamous to being a monogamous one. Yeah, this is something you need to remember. Conversion of marriages. For a person to convert a potentially polygamous marriage, yeah, into a monogamous marriage, the husband at that particular point in time must have had only one wife. Should that man have more than one wife, then he is forever in a potentially polygamous marriage, and he can continue marrying any number of women he wants, meaning that no woman amongst his many wives can agree with him to convert the specific marriage from being potentially polygamous to a monogamous one. Number 2, when this happens, there has to be a declaration witnessed by a marriage officer, recorded in writing and signed by the couple, meaning that if you went for a traditional Kikuyu wedding and your husband up to now has you as his only wife, then you can actually change that situation by converting your marriage into a monogamous one. Going ahead, of course, to declare, do a declaration with a marriage officer, and then it's written and it's signed by the couple. This is according to section 8.3 of the Marriage Act of Kenya 2014. The next step is that now the registrar will go ahead to issue a new certificate registering your marriage as monogamous. Now you've converted from a potentially polygamous marriage to a monogamous one, but you've seen the conditions that have to be met. Your husband must have only you at that particular point in time. Should he have more than one wife, then you can never convert your marriage from a potentially polygamous one to a monogamous one as far as conversion of marriages is concerned in Kenya. Having understood about conversion of marriage, one thing I want to tell you as a student of family law is that you need to understand section 8 and 9 and have it at the back of your mind, because there's so many fact-based questions that can be set rotating around section 8 and section 9 of the Marriage Act of Kenya 2014. And again, to bring you back to this specific slide, we are discussing about subsisting marriages, meaning that a person already has an existing valid marriage. And so, as you can already see, if a person is in a monogamous marriage, that person cannot contract another marriage. So, giving you an example here, if Njoroge is in a civil marriage or a Christian marriage, which is by its nature supposed to be monogamous, meaning that you must have one wife, if Njoroge goes ahead to marry another woman outside his first marriage, is contracting an extra marriage, that second marriage is considered invalid. The law does not recognize it as far as section 9 of the Marriage Act of Kenya is concerned. Now, remember we talked about situations under which you can change a monogamous, or rather a polygamous or potentially polygamous marriage into a monogamous one, and we had this discussion in the previous slide. But also you need to remember that no person in a polygamous or potentially polygamous marriage can contract a monogamous marriage. So if you already have 3 wives, you can't say then that you're contracting a monogamous marriage. It doesn't even make a logical sense. And this is in regard to section 9B of the Marriage Act of Kenya. And so remember these things, you need to have them at the back of your mind. You may have fact-based questions that are rotating around a man in a potentially polygamous marriage with about 4 women is now contracting a monogamous marriage. Of course, that doesn't make sense as far as subsisting marriages are concerned, and specifically section 9B of the Marriage Act of Kenya. Put section 8 and 9 at the back of your mind at all times. Now, up to this point in time, if you're new to Nairobi Legal, please consider subscribing. You can give this video a thumbs up and comment below for any particular questions. I'm going to answer them. Engage me in any conversation that you may want as far as family law is concerned. Now, with that short break, there are certain prohibited marriage relationships as far as the Marriage Act of Kenya is concerned, meaning that should a person marry anyone in the group provided for under Section 10 of the Marriage Act of Kenya, that marriage is considered to be invalid. I mean, it is not lawful. Yeah, and we are going to be appreciating also that there are certain exceptions under which Muslims can go ahead to marry their cousins, and the law protects them, and the law allows for this because it is not prohibited in their culture. And this is specifically Section 10 of the Marriage Act that allows Muslims to go ahead and marry their cousins. Now, as stated earlier, these are the prohibited marriage relationships, and this is within the law, meaning that again, you can't marry your aunties, you can't marry your cousins, your uncles, your parents, your grandparent, you can't marry your child. Basically, if you actually go contract any marriage within this category, then I mean, you're wasting your time. It will not be recognized by law. And the other thing you need also to appreciate is that for Muslims, like I stated earlier, they're allowed to go and marry their cousins, while for Christians and other people, so long as you're not actually professing the Islamic faith, you can't marry your cousins. Muslims are just given an exception because their faith allows that to happen. And so, as a family law student, put this list at the back of your mind and remember Section 10 of the Marriage Act of Kenya. According to Section 16 of the Marriage Act of Kenya 2014, a marriage may come to an end if either of the spouses dies, or if there is a decree declaring a presumption of death. An example would be that if Njoroge is married to Jane and Njoroge disappears for 5 years, there is a presumption of death. Maybe Jane may assume Njoroge died, so she gets this decree declaring a presumption of death, then the marriage will come to an end. We can also have a decree of annulment for certain reasons that we're going to be discussing in more videos to come. So up to this point in time, if you're new and you haven't subscribed, remember to subscribe, and you need to put on the notification bell so that each and every time I'll be posting a video on family law in Kenya, you're going to be able to receive notifications. Now, the other way in which a marriage can come to an end through divorce, and of course you can already see also there can be a foreign decree of divorce and annulment, so long as it's recognized in Kenya under the Act. So these are situations under which a marriage may come to an end according to the Marriage Act of Kenya 2014. In our next video, we are going to be looking at the different types of marriages in Kenya and the specific legal requirements that must be fulfilled for those marriages to be valid according to the Marriage Act of Kenya 2014. If you're new here again, consider subscribing. You can give me a thumbs up. I'll appreciate that. Thank you.